Be quiet. Now, she asks you questions. You wait till she finishes.
I'm a grown man.
Mr. Hastings, don't press your luck with me, son. Don't press your luck with me.
Or what? You gonna sentence me? Is that what you're gonna do?
You know what, Mr. Hastings? I am.
Okay.
Let me tell you why.
I don't really want to care why. Just get on with the
Just shut your mouth, sir.
Oh, I'm not gonna shut my mouth.
Next time, I'm going to have you gagged. And if you're too stupid to know that what I'm trying to do is protect you, then let me spell it out for you. I am trying to protect you, your rights, and your freedom.
This whole case was fishy, and I have no idea how to. You know what?
Their address on file.
You know what?
The state intends to amend
I'm
the
granting.
charge and proceed on
I'm rescinding the sentence. I'm granting the JOA.
Judge James Hankinson. Arguing with a judge in court is a dicey move. That's even more true when you're the defendant in that murder trial, and jurors are watching. That's what happened to Florida man Henry Segura when he was being cross-examined on the stand Wednesday. Judge James Hankinson is known as a firm but fair judge who presided over some of Tallahassee's most notorious murder cases. But even he has limits when it comes to disrespectful defendants. On the third day of his trial, Hankinson lost his patience with Henry Segura, who was arrested for killing his girlfriend and her 3 children, their 3-year-old son, Cavante Segura, and Tamaya and Tanaya Peters, the victim's daughters. Segura, who pleaded not guilty, was facing the death penalty if convicted. His first trial ended in a mistrial after the jury was deadlocked 8-4 in favor of acquittal. On the third day of his retrial, Segura faced a fierce cross-examination by Assistant State Attorney John Fuchs, who challenged his credibility and alibi.
No, that you did not tell police that.
Yes, I told the lady Johnson, Investigator Johnson,
You told
over
her
the phone that I was cheating on my wife. I didn't want y'all to find out, and she, excuse me, and she, like I say, she went back and forth, and we was arguing about. She know I killed my son. We're gonna arrest you for killing your son, and I hung up on him.
Fuchs repeatedly asked Segura why he lied to the police and changed his story several times. Segura became frustrated, interrupting Fuchs' questions, saying that he was asking the same question repeatedly.
The testimony is that you told police in this case over the phone.
Investigator Johnson.
Wait a minute, don't interrupt her question, Mrs. Garrett. Let her finish her question.
She's asking the same question over and over.
Be quiet.
No, she's.
Be quiet.
The judge told Segura not to interrupt the prosecutor's question.
Be quiet. Now, she asks you questions. You wait till she finishes.
I'm a grown man.
Hankinson told him to wait for the prosecutor to finish her question before answering. Then he asked them if this was clear. The exchange, lasting for about a minute, was captured on video and went viral on social media. Many viewers commented on the disrespect and audacity that Segura showed to the judge and wondered how it would affect the jury's perception of him. Judge Fred Schott. On March 11, 2023, a Seminole County courtroom witnessed a rare and dramatic scene. A judge who reversed a jury's guilty verdict and accused a police officer of lying under oath. The case involved Lisette Gonzalez, a 46-year-old woman who was stopped and apprehended by police for DUI by Sanford officer Michael Wagner. Wagner claimed he saw her sipping from a can of natural ice beer while driving on St. John's Parkway and then took her to the Seminole County Jail. However, he didn't perform a breath alcohol test and instead checked a box on the DUI citation saying that her blood or breath alcohol level was above 0.08, the legal limit. That resulted in the immediate suspension of her driver's license. 2 months later, Gonzalez was pulled over by an Alamonte Springs officer and ticketed for driving with a suspended license. She pleaded not guilty to both charges and went to trial. The jury found her guilty of DUI, but not of driving with a suspended license. Judge Fred Schott, who presided over the trial, was unsatisfied with the verdict.
Why wouldn't you? Wait a minute. Did you hear the uncontroverted testimony of this officer?
Officer Wagner testified that he made a mistake in marking a box, charging and arresting Miss Gonzalez where she had a 0.08 or high alcohol blood content with a breathalyzer test.
But you did not know what her blood or breath alcohol was at all, did you?
That's correct. Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is not true.
He questioned Wagner's testimony and credibility, demanding that the prosecutor, Assistant State Attorney Diana Myers, drop the suspended license case and charge Wagner with perjury. Myers refused, saying that Wagner made a mistake, not a lie. Schott then got angry and pounded the bench with his hand.
This whole case was fishy, and I have no idea how they... You know what?
Their address on file.
You know what?
The state intends to amend
I'm
the charge
granting.
and proceed on
I'm rescinding the sentence. I'm granting the JOA.
He announced that he was rescinding the sentence and granting a judgment of acquittal or JOA for Gonzalez, effectively overruling the jury's decision. He told the prosecutor to appeal.
I'm dismissing the charge. You can appeal.
We will, Your Honor. Please provide us a written order.
No. I'm dismissing the charge. So take it up on appeal with him lying about it. The case should have never been done. Never. And we'll find out why your license was suspended and if somebody broke the law to cause your license to be suspended.
He also ordered a new hearing for the suspended license case and told Myers to appeal his ruling. Judge Bruce Schroeder. The trial of Kyle Rittenhouse, the teen accused of killing 2 people and wounding a third during protests in Kenosha, Wisconsin last year, has been marked by high emotions, dramatic testimony, and heated exchanges between the judge and the prosecutor. Twice during cross-examination, the judge asked the jury to leave the courtroom and then sharply admonished Kenosha County Assistant District Attorney Thomas Binger for his line of questioning. Let me give you a quick backstory on this case. Rittenhouse shot Joseph Rosenbaum, Anthony Huber, and Gage Grosskreutz with an AR-15 style rifle on August 25, 2020. Amid unrest sparked by the police shooting of Jacob Blake, a black man who was left paralyzed. He claimed he acted in self-defense when he shot at Rosenbaum. Lead prosecutor Thomas Binger argued Rittenhouse was the aggressor who provoked the violence and had no legal justification to use deadly force. The defense, led by Mark Richards, has portrayed Rittenhouse as a young patriot who went to Kenosha to protect property and provide medical aid, and who feared for his life when he was chased and attacked by angry protesters. Now, this trial, which began on November 1st, has been closely watched by the public and media, raising questions about gun rights, self-defense, racial justice, and political polarization in the U.S. One of the most controversial figures in the trial has been the presiding judge, Bruce Schroeder, Wisconsin's longest-serving circuit judge who has a reputation for being tough and independent. The berating occurred after Thomas Binger attempted to ask Rittenhouse if he was using his AR-15 style rifle to protect property rather than human life.
Your AR-15 to protect someone's property, correct?
I'm going to ask you to go into the library again for a moment, please. Please don't talk about the case.
Lead defense attorney Richards accused Binger of ignoring previous rulings or attempting to provoke a mistrial.
Your Honor, Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice.
That would prevent the state from re-prosecuting the case. Schroeder tore into Binger for commenting on Rittenhouse's silence to the authorities. The judge dismissed the jury and started screaming at Binger when the lead prosecutor suggested the court left the door open for specific lines of questioning, including the line of questioning he elicited from the defendant.
First of all, Your Honor, this was the subject of a motion. I'm well aware of that, and the court left the door open.
For me, not for you.
My understanding of
you should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move
that
to
was
reconsider.
Their motion.
We have not filed any motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that made it okay for you, without any advance notice, to bring this matter before the jury. I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that.
Binger responded that he was trying to impeach Rittenhouse in his line of questioning by arguing that the incident was identical to what was going on the night of August 25th, in the sense that the defendant was using the same weapon. He was using it in a manner to protect property.
Yeah, that's absolutely untrue. No. Your arguments of record, my comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
He tore into Binger again for violating his ruling and trying to introduce evidence that could prejudice the jury against Rittenhouse.
And by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense testimony.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that.
Schroeder said that Binger had committed a grave constitutional violation by implying that Rittenhouse's silence was evidence of guilt. Judge John Wulle. Judge John Wulle was once a respected jurist in Clark County, Washington, who had served as a Superior Court judge since 2000. But in 2012, his career came to a screeching halt when he faced multiple disciplinary charges for his rude and undignified behavior in court. Judge Wulle was sentencing Matthew R. Hastings in Clark County Superior Court when the two exchanged heated words. Hastings had been convicted on 4 counts of attempted murder and 2 counts of second-degree assault for taking a hostage and shooting at police during a standoff in Vancouver in July 2007.
Now, having said that, Mr. Hastings, did you graduate from high school, sir?
No.
Okay, let me give you a little thumbnail sketch of the American system of government. Mr. Hastings, don't press your luck with me, son. Don't press your luck with me.
Or what? You gonna sentence me? That what you're gonna do?
You know what, Mr. Hastings, I am.
Okay.
Let me tell you why.
I don't really want to care why. Just get on with
You shut your mouth, sir.
Oh, I'm not gonna shut my mouth.
Next time, I'm gonna have you gagged.
After a brief heated exchange, the judge excused himself and summoned both attorneys into his chambers. When he returned, the judge apologized for using the word damn to anyone who was offended. Mr. Hastings pushed buttons, Wulle said. I do apologize if I offended anyone in this courtroom. However, Mr. Hastings' case was not the only one he got in trouble for. Another notorious incident involved a juvenile defendant who wanted to represent himself in a criminal case. In 2011, Judge Wulle presided over a hearing for a 15-year-old boy who was accused of second-degree assault with a deadly weapon. The teenager didn't want a lawyer and tried to admit to the probation violation that landed him in Clark County Juvenile Court.
I'd like to fight for myself and not have an attorney.
Oh, that's not a smart play. That's like going out on the field with the New York Yankees and you've never even learned how to play baseball.
That's fine.
I'm not going to do that. You're going to have an attorney assist you in this matter.
But Judge Wulle wasn't sympathetic to the boy's plight. As the teenager insisted, Wulle lost his cool.
I'm doing my job, sir. My job requires that I protect your constitutional rights, you as an American citizen.
He pointed out that the teenager needed to have a lawyer represent him, and he wouldn't allow the teen to bring disrepute to his courtroom for his lack of understanding of the law. This decision didn't sit well with the boy and his mother, as they wanted to plead guilty. This time, Judge Wulle tore into him.
And if you're too stupid to know that what I'm trying to do is protect you, then let me spell it out for you. I am trying to protect you, your rights, and your freedom.
Instead, he berated him for his choice, interrupted him, raised his voice, and threatened to hold him in contempt of court. He also refused to accept his guilty plea, saying he wasn't competent to represent himself. He ordered him to keep his public defender, who had advised him against self-representation. The judge's harsh demeanor was captured on video, which was later submitted as evidence to the Washington Commission on Judicial Conduct, the state agency that oversees ethics and discipline of judges. The commission charged him violating multiple parts of the Code of Judicial Conduct, which required judges to maintain order and decorum in court and to be patient, dignified, and courteous to everyone. Judge Wulle initially denied the charges, but later admitted that his conduct was inappropriate and violated the code. He also apologized to his family and the public. He said at the time he was under a lot of stress and pressure and had made mistakes. And that's it for today's video. If you want to see more crazy criminal courtroom cases, check out this video, and please don't forget to subscribe.